Hi, my name is Lauren DeMoss, a healthcare attorney with Maynard Nexsen, and I counsel entities on compliance with the HIPAA, privacy, security, and breach notification regulations. Vendors represent a constant threat to an organization's sensitive data, and as the organization cannot directly control the vendor's HIPAA security program. And as we have often seen, incidents commonly originate with third and fourth parties. As a result, healthcare providers must be prepared to try to prevent as well as respond to such occurrences. In order to mitigate the threat of a HIPAA breach that originates with a vendor, in addition to ensuring that a business associate agreement is in place, providers should consider implementing the following 4 practices with respect to vendor management. First, include enhanced audit rights in the business associate agreement. This enhanced audit right goes beyond the typical access to books and records provision and expands the covered entity's ability to ensure vendor compliance. A covered entity would be permitted to inspect the facilities, systems, books, procedures, and records of a business associate in order to monitor compliance with the business associate agreement. This could be done as frequently as annually. Further, in the event an audit revealed areas of vulnerability, the business associate would be required to create an action plan to remedy any violation promptly. Second, have a clear policy on how a vendor incident would be managed by a covered entity. Vendor incidents present unique challenges. In a third or fourth party incident, an organization is beholden to the vendor for information about the incident, and the organization needs that information in order to perform a technical and legal evaluation. Expectations must be managed with vendors before, during, and after an incident through the governing agreement and through the incident response process. Key points of contact within the covered entity and escalation points and procedures should be memorialized in writing, and expectations should be communicated to the vendor. Third, in addition to indemnification rights, include a provision in the business associate agreement that allows for reimbursement of cost associated with a breach. The indemnification provision typically only allows for indemnification in the event of a violation of the agreement, and a breach can sometimes occur even though the business associate may not technically be in breach of the agreement. In other words, the right to reimbursement is not predicated on any breach or act or omission by the business associate. It would allow for strict reimbursement of any expenses incurred by the covered entity that are associated with the breach. Fourth, there should be no limitation of liability provision in the business associate agreement. A vendor may seek to impose limitations of liability in the master agreement, especially if the master agreement is a vendor form. Healthcare providers should develop internal guidelines for the contract negotiation process addressing acceptable limitations of liability that align with the organization's risk appetite, cyber insurance coverage, and the particular risk profile of the vendor, based in part on the nature and volume of electronic PHI to which the vendor will have access. Ideally, any violations of the business associate agreement would be carved out from any applicable limitations of liability. The healthcare team at Maynard Nexsen stands ready to help both covered entities and business associates strengthen their security and comply with the HIPAA regulations.